The court notes an anomaly in the documentary record. Judge Patricia Weller's voice had carried the flat, practiced authority of 14 years on the bench through every word of the morning session, every objection sustained, every instruction given, every ruling delivered with the same measured cadence. But something changed when she reached page 3 of Exhibit 22, and the people who were paying close attention would later say that the change wasn't dramatic, wasn't loud, wasn't anything you could easily describe to someone who hadn't been in the room. It was a pause. A specific kind of pause, the kind that doesn't come from uncertainty but from recognition. She adjusted her reading glasses with one finger. She looked at the document again, and then she read the name aloud. Harlan Voss Whitmore. 4 seconds of silence. Then 5. Then the ventilation system in Room 9 of the Crestfield County Courthouse in Dunmore, Pennsylvania, continued doing what it always did, and the fluorescent lights continued their faint hum above the gallery benches, and somewhere in the back of the room a person shifted in their seat and the wood creaked, and none of that noise filled the silence so much as it outlined it. What makes that moment unusual is not that a judge paused on a name. What makes it unusual is what that name did to the room. Defense counsel Margaret Olin, 47 years old, 12 years in criminal trial practice, did not move. She was looking at the bench. Her pen, which had been making notes in the margin of her legal pad at a steady pace all morning, had stopped. It was still touching the paper. She was not writing. Prosecuting attorney Derek Marsh, seated across the aisle, had turned his head at an angle that suggested he was looking at his co-counsel without fully turning to face her. His jaw had tightened. Not dramatically. Just enough. The defendant, a 39-year-old man named Calvin Pruitt, who had been sitting at the defense table with the careful stillness of someone who had been coached extensively on how to appear in a courtroom, had done something that nobody on his team had apparently prepared him for. He had exhaled. Not loudly. Not visibly to most of the gallery. But Margaret Olin, who was sitting 18 inches to his left, heard it. She would describe it later, in a conversation with a colleague, as the sound of someone who has been holding their breath for a very long time and suddenly, involuntarily, cannot hold it anymore. She didn't know yet what it meant, but she wrote the name down. To understand why those seconds mattered, you need to understand what kind of case this was supposed to be, and what kind of case, by the time that name was read aloud, it had quietly become. Calvin Pruitt had been charged with 1 count of wire fraud and 2 counts of filing false financial instruments, federal charges that had been referred to the state level through an interagency arrangement that the charging documents described in language so technical that most of the local coverage had summarized it simply as Dunmore contractor accused of faking documents to collect insurance payout. That summary wasn't wrong. It was just incomplete. The official version of events, according to the prosecution's theory, was this. Pruitt, who operated a mid-sized construction and renovation company called Pruitt Built LLC out of a commercial address on Garfield Avenue in Dunmore, had submitted fraudulent completion certificates and inflated materials invoices to an insurance carrier in connection with a commercial fire damage claim. The property in question was a warehouse on the eastern edge of the county, a 2-story industrial building that had sustained significant fire damage 18 months before the trial began. Pruitt's company had been contracted to assess and restore it. The insurance carrier, a regional firm called Landmark Mutual, had paid out based on Pruitt's submitted documentation. Landmark Mutual subsequently discovered discrepancies in the materials costs and initiated an investigation. The investigation led to the fraud charges. At first glance, it was an unpleasant but relatively contained case. A contractor who padded an invoice. Insurance fraud of this type costly, harmful, but not uncommon, typically resolved through negotiated settlements or plea agreements. The fact that this one had gone to trial at all was, to several attorneys familiar with the Crestfield County docket, mildly surprising. Margaret Olin had been surprised too when Pruitt retained her. She'd asked him, directly, in their first meeting, why he wanted to fight it rather than negotiate. He'd told her the charges weren't accurate, that the documentation had been prepared according to the contract specifications, that he had been set up. Olin had heard that before. Most defense attorneys have, but something in the way Pruitt said it, not with indignation, not with the performative certainty of someone insisting on innocence because insistence is the only play left, but with the specific, flat exhaustion of a man who had been trying to explain something to people who kept not listening, had made her want to look at the documents herself. She looked, and the documents were, on their surface, exactly what the prosecution said they were: inflated, inconsistent with market rates, and signed by Pruitt. But there was one thing she hadn't been able to explain in 11 months of pretrial work. The contract itself, the original agreement between Pruitt Built LLC and the property owner, bore a signature she had never been able to match to a person, not the property owner's signature, not Pruitt's. A third signature, on the project addendum page, in a line designated for what the contract called the authorized oversight agent. The signature was a quick, angular scrawl. The printed name beneath it was partially illegible in the photocopy she'd been working from. It looked, she had thought, like it might begin with an H. Court records later revealed that Exhibit 22 had been in the evidence file since pre-trial discovery. It was a supplemental insurance filing, a secondary document submitted to Landmark Mutual 6 weeks after the initial claim, containing additional materials specifications and a revised project scope. The prosecution had introduced it as supporting documentation for the fraud theory. The revised scope, they argued, was where the inflated figures first appeared. What nobody had apparently examined in 11 months of litigation was page 3 of that document. Page 3 was a signature authorization sheet, the kind of form that appears in commercial insurance filings, to confirm that all parties to the contract have reviewed and approved the revised scope. There were 3 signature lines. 2 of them matched the known parties, the property owner, and Pruitt himself. The third line, which was labeled Authorized Agent/Project Guarantor, bore the name Harlan Voss Whitmore, printed neatly, in capital letters, above a signature that was different from the one on the original contract. Judge Weller had found it because she was reading carefully. She read everything carefully. It was one of the things that made her, depending on who you asked, either the best or the most demanding judge in the county. She set the document down and looked at the prosecution table. "Mr. Marsh," she said, "can you identify the third signatory on page 3 of Exhibit 22? Derek Marsh stood. He was 44, broad-shouldered, with the kind of confident bearing that comes from winning consistently enough that winning feels like the natural order of things. He looked at his co-counsel, a younger attorney named Sarah Enfield, who was already pulling documents, and then back at the bench. "Your Honor," he said, "that signature line represents a standard authorization form used by Landmark Mutual for revised scope filings. The third party listed would have been a project guarantor, a formality in contracts of this size. We can pull the full documentation on that signatory." "Can you?" Judge Weller said. It was not a question. "We can, Your Honor. It may take a short recess to locate the relevant records." Weller looked at him for a moment, with the particular patience of someone who is deciding whether what they're hearing is incompetence or something else. "The court will recess for 15 minutes, she said. "I'd like the full documentation on the signatory identified as Harlan Voss Whitmore on my desk before we reconvene. If that documentation, exists. The way she said that last sentence, if that documentation exists, was the moment Margaret Olin understood that something had changed in the room. She wrote the name down again, underlined it twice. The 15-minute recess became 35 minutes. Olin used the time. She stepped into the corridor outside room 9, a marble-floored hallway with tall windows that looked out onto the courthouse parking lot and let in the kind of flat November light that makes everything look slightly overexposed, and called her paralegal, a meticulous 28-year-old named James Corey, who had the specific gift of finding things in public records that other people had looked directly at and not seen. "Run Harlan Voss Whitmore," she said, before he could speak. "Pennsylvania, Delaware, anywhere. Corporate registries, professional licenses, anything. Call me back in 20 minutes. Corey called back in 14. What he had found in 14 minutes was enough to make Olin stand very still in that corridor for a moment before she went back inside. Harlan Voss Whitmore was a licensed commercial insurance adjuster. He had been licensed in Pennsylvania since 2009. His professional address was listed as a firm called VW Consulting Group, operating out of an office suite in Harrisburg, about 90 miles west of Dunmore. His license was current. He had no disciplinary record. And he was, according to the corporate registration filed with the Pennsylvania Department of State 14 months before the fire at the warehouse, a registered officer of Landmark Mutual's third-party claims assessment division. Olin went back inside and sat down. Calvin Pruitt leaned toward her slightly. "What did you find?" She kept her voice below the gallery noise. "The person who signed your contract addendum works for the insurance company that's suing you." Pruitt looked at her for a long moment. Then he said something that she had not expected. He said, "I know. I've been trying to tell someone that for 11 months. This is the moment the case pivots, and it's worth slowing down here, because the pivot is not a dramatic explosion. It's a quiet, documentary pivot. The kind that happens when a piece of information that was always present finally connects to a piece of information that was already known, and the distance between them turns out to have been the entire structure of someone's deception. Let's go back to the beginning of the project. Not the charges, the project itself. The warehouse on the eastern edge of Crestfield County was owned by a holding company called Dunfield Property Group. Dunfield had owned the building for 7 years, using it primarily for equipment storage and light industrial leasing. The fire that damaged it occurred on a Tuesday evening in late October, an electrical fire, per the initial fire marshal's report, originating in the second-floor electrical panel. The fire marshal's report classified it as accidental. Pruitt Built LLC was not the first contractor contacted for the restoration assessment. Records show that 2 other local contractors had been approached first. Both declined, one citing scheduling, one citing the scope of the damage assessment required. Pruitt accepted the contract. The terms of that contract were standard in most respects. Pruitt would assess the damage, produce a scope of work, and manage the restoration in coordination with Landmark Mutual's claims process. The contract contained one non-standard element, the authorized oversight agent line. Pruitt had not drafted that language. He had not requested it. He had asked his contract attorney about it at the time and been told it was a Landmark Mutual requirement for claims above a certain threshold. He signed the contract with that line already included and a name he didn't recognize already printed in it. That name, he would later tell Olin, was the same name the judge had just read aloud. What makes this detail unusual is what it means for the prosecution's theory. If the insurance company's own oversight agent was a signatory on the original contract, if a Landmark Mutual employee had been present and authorized in this project from the beginning, then the claim that Pruitt had unilaterally inflated the documentation becomes significantly more complicated, because someone else had access to that documentation. Someone who knew the claims process from the inside. Someone whose name for 11 months had been sitting on page 3 of Exhibit 22 without anyone asking who he was. When court reconvened, Derek Marsh was standing at his table with a composure that Olin, watching him, noted was slightly different from his morning composure. Still controlled, but controlled in a different way. The morning composure had been the ease of a man who believes he's winning. This was the composure of a man who is working to maintain something. He addressed the bench. "Your Honor, we have located partial records relating to the signatory in question. Harlan Voss Whitmore was identified as an authorized oversight agent appointed by Landmark Mutual for this specific project under their third-party claims management program. His role was administrative. He reviewed documentation for completeness. He had no material involvement in the substance of the claims filed." Judge Weller looked at him. "Mr. Marsh, if Mr. Whitmore reviewed the documentation for completeness, does that documentation include the revised scope filing in which these allegedly fraudulent figures appear?" A pause. "It would have included that, yes, Your Honor." "And Mr. Whitmore reviewed it and approved it?" Another pause. Shorter, but noticeable. "His signature on the authorization sheet suggests he reviewed it, yes. So the documentation that forms the basis of these fraud charges was reviewed and signed by an employee of the institution that filed the charges." Marsh said, "Your Honor, his review was procedural in nature. I understand your position, Mr. Marsh. I'm establishing the record." She turned to the jury. "Ladies and gentlemen, I'm going to ask you to step out for approximately 1 hour. We have a preliminary legal matter to address before testimony continues." The jury filed out. 12 people who had been listening to a fraud case about a contractor and inflated invoices, now walking into a deliberation room with the specific unsettled feeling of people who sense that the thing they're watching has become a different thing, but not yet knowing what. What happened in the next hour, outside the jury's presence, was not recorded verbatim. The transcript shows the arguments but not the atmosphere, and the atmosphere, by multiple accounts, was one of those rare courtroom moments where everyone in the room understands simultaneously that the floor plan of the case has changed. Olin filed an oral motion for expanded discovery. She asked for the complete personnel records of Harlan Voss Whitmore in relation to his work on the Dunfield project, all internal communications between Whitmore and Landmark Mutual's claims division during the relevant period, and all documentation relating to how and why Pruitt Built LLC was selected as the restoration contractor after 2 other firms had declined. That last request, why Pruitt's company had been selected, was the one that produced the most reaction. Marsh objected. He called it a fishing expedition. He argued that Whitmore's involvement was procedural and immaterial, and that the discovery request was a delay tactic designed to muddy a straightforward evidentiary record. Olin said, "Your Honor, the prosecution has spent 11 months presenting my client as the sole architect of a fraud scheme involving documentation that was reviewed and signed by a representative of the institution accusing him. We are not fishing. We are asking why that person's name was not disclosed in any of the pre-trial materials and why it took the court reading page 3 of Exhibit 22 aloud for anyone to acknowledge his existence." Judge Weller took 11 minutes to rule. She granted the discovery request. All of it. She also did something that Olin had not anticipated. She issued a sua sponte order, meaning on the court's own initiative without a request from either party, directing Landmark Mutual to provide a representative to testify regarding their third-party oversight program and specifically regarding Whitmore's appointment and role in the Dunfield project. She gave Landmark Mutual 72 hours to comply. The trial was recessed. In the corridor afterward, Marsh walked past Olin without making eye contact. His co-counsel Sarah Enfield stopped briefly, looked at Olin with an expression that was not quite readable, and then continued walking. Calvin Pruitt stood at the window at the end of the corridor, looking out at the parking lot in the November light, and said nothing for a long time. Then he said, "Do you believe me now?" Olin looked at the name she had written twice on her legal pad. "I'm starting to," she said, "to understand the right questions." Here is the part of the story that requires the level 4 lens, the summary view, the look backward across a longer timeline. Because what the 72-hour discovery period uncovered did not come from a single document. It came from the intersection of several documents that had each, separately, looked entirely ordinary. James Corey worked for 31 consecutive hours during that recess. He later described the process as like watching a picture develop in a darkroom. Each chemical adds something, and you keep waiting to see if it's a face. The first chemical was Whitmore's employment history. His LinkedIn profile, still active, last updated 4 months before the trial began, listed his role at VW Consulting Group and, before that, a 7-year tenure at a regional commercial insurance firm called Eastern Apex. Eastern Apex had merged with Landmark Mutual in 2019. When Eastern Apex merged, its senior personnel had been absorbed into Landmark Mutual's operational structure. Whitmore had come over in that absorption. He was not a recent hire. He was not a peripheral contractor. He was a 14-year insurance professional with deep institutional knowledge of exactly the kind of claims process that the Dunfield project had moved through. The second chemical was the project selection history. Corey filed a public records request with the county building department for all permit activity on the Dunfield warehouse address going back 5 years. What came back showed something no one had previously mentioned in any filing. The warehouse had undergone a permitted electrical upgrade 18 months before the fire. The contractor who performed that upgrade was not Pruitt Built. It was a firm called Crestline Technical Services. Crestline Technical Services had its own corporate registration history. Its registered agent, listed in the state records, was a name Corey recognized immediately. V. Dual Consulting Group. Whitmore's firm. The same firm that had placed Whitmore on the Dunfield restoration project as Landmark Mutual's oversight agent. This meant that a company connected to Whitmore had done electrical work on the warehouse. The warehouse had subsequently had an electrical fire. The fire had generated an insurance claim. Whitmore had then been appointed by the insurance company he worked for as the oversight agent for the restoration project. And the restoration contractor on that project was now on trial for fraud. Corey sent Olin the documents at 2 a.m. with a message that said only, "The picture has a face." Olin spent the remaining hours before the resumption of trial building the argument in 2 directions simultaneously. The first direction was what she now believed had actually happened, that the fire at the Dunfield warehouse was not the accidental electrical event the fire marshal had concluded, that the project had been structured to generate an inflated insurance claim from the beginning, and that Calvin Pruitt, whose company had been selected after 2 other contractors declined, whose contract had included an oversight agent clause he didn't draft, and whose documentation had been reviewed and signed by that agent, had not been the architect of the fraud. He had been the instrument of it. The second direction was more legally immediate. She didn't need to prove all of that in order to win. She needed to introduce enough documented doubt about the prosecution's theory to shift the evidentiary weight. The name on page 3 had already done part of that work. The documents Corey had found did more, but she was also thinking about something else, something that the documents suggested but didn't prove. If Whitmore had been placed on this project specifically, if his appointment as oversight agent had been deliberate rather than procedural, then someone had made that appointment. Someone at Landmark Mutual had selected him, and that person, whoever they were, had either known what the project was for or had been given no reason to ask. She needed to know which one. When the trial resumed on the morning of the fourth day, the atmosphere in Room 9 had changed in the specific way that courtroom atmospheres change when something has shifted in the record and everyone knows it but the jury is not yet caught up. The gallery was fuller than it had been. Word travels in county courthouses. It always does. And the word that had traveled in Dunmore in the past 72 hours was imprecise but directionally accurate. Something happened in that fraud case. Something with a name. The landmark mutual representative who appeared pursuant to Judge Weller's order was a woman named Catherine Hollis, Senior Vice President of Claims Operations, 53 years old, with the composed and careful manner of someone who has spent many years being the person an institution sends to rooms where things need to be managed. She was not the person who had appointed Whitmore to the project. That decision, she explained, had been made by a regional claims director named Paul Stenberg, who was currently on medical leave. Judge Weller noted that for the record. Olin Cross examined Hollis for 40 minutes. She was methodical. She did not dramatize. She asked about the third-party oversight program, when it had been established, what its criteria were, how oversight agents were selected for specific projects. Hollis answered carefully, consulting notes she had brought, acknowledging that the program had been implemented after the Eastern Apex merger and that its procedures were still, in her word, evolving. Then Olin asked about Crestline Technical Services. Hollis paused. I'm not familiar with that name in the context of this case. Are you familiar with it in any context? I'd need to check our vendor records. Your vendor records, Olin said. Is Crestline Technical Services a landmark mutual vendor? A longer pause. I would need to verify that. Olin introduced the corporate registration documents. She introduced the connection to VW Consulting Group. She introduced the permit history on the Dunfield warehouse, showing Crestline's electrical work 18 months before the fire. She did not accuse. She asked questions. Each question led to the next, and the pattern they formed, in the room, in the jury box where 12 people who had thought this was a contractor fraud case were now listening with very different attention, was a pattern that had a shape even before it had a name. At the plaintiff's table, Derek Marsh made objections. Some were sustained. Most, given the scope of the discovery order Judge Weller had already issued, were overruled. And then Olin asked the question she had been building toward for 40 minutes. Miss Hollis. In the landmark mutual records relating to this project, the Dunfield warehouse restoration claim, is there any documentation showing that Harlan Voss Whitmore flagged concerns about the revised scope filing before it was approved? Hollis looked at her documents. A long look, the kind of look that is partly reading and partly deciding. There is a notation in the file, she said. Olin waited. There is an internal notation dated 6 weeks before the fraud charges were filed. It indicates that Mr. Whitmore submitted a concern to the Regional Claims Office regarding certain cost figures in the revised scope. The room was very quiet. And what happened to that concern? Olin asked. According to the file, it was reviewed and closed by the Regional Claims Director, by Paul Stenberg. Yes, the same Paul Stenberg who appointed Mr. Whitmore to the project. Yes, and who is currently on medical leave. That is correct. Olin looked at the jury for a moment, not to signal anything, just to let the room breathe. Then she said, "No further questions, Your Honor." The final reveal in this case did not arrive in a single dramatic moment. It arrived the way most genuine revelations arrive in legal proceedings, incrementally, through documents, through the accumulation of facts that individually seem explainable but together cease to be. Paul Stenberg, the regional claims director on medical leave, was not, it turned out, on medical leave in any traditional sense. He had submitted a medical leave request 11 days after Olin's discovery motion had been filed. Before the trial resumed, before the Hollis testimony, while the 72-hour recess was still in progress. The timing of that request would later be noted in the investigative documents as consistent with awareness of pending legal exposure. Whitmore, for his part, had not been passive during the 72 hours either. His attorney, a Philadelphia firm that notably did not appear on any Landmark Mutual panel, had contacted the district attorney's office with what was characterized in subsequent filings as a proffer of cooperation. Whitmore, through counsel, indicated a willingness to provide information regarding the Dunfield project in exchange for consideration in any separate proceeding that might arise from the investigation. The proffer was accepted. What Whitmore described, in statements that would later be corroborated by documents obtained from Landmark Mutual's claim servers through a court order, was a scheme that had been running in various forms for approximately 4 years. The structure was consistent, a property would sustain damage, sometimes accidental, sometimes not, a restoration claim would be filed, and through the third-party oversight program, a connected oversight agent would be placed on the project. The oversight agent would review the revised scope documentation, approve figures that had been inflated beyond the actual damage, and the excess payout would move through a series of vendor invoices, companies like Crestline Technical Services, before being distributed. Pruitt had been selected for the Dunfield project, according to Whitmore, specifically because he had no prior relationship with any of the parties involved. He was clean, no history with Landmark, no connections to the network. No reason to ask the questions someone with inside knowledge might ask. He had been given a contract with a pre-inserted oversight agent clause. He had been given a revised scope with figures he had not generated. He had signed documentation he had been told was standard. When he had started asking questions, when he had noticed partway through the project that some of the materials costs in the revised scope didn't match what he had actually ordered, he had been told by the project coordinator, a man connected to Stenberg's office, to submit the documentation, as provided. He had submitted it. And 6 months later, he was charged with fraud. He had, as he had told Olin in their first meeting, been set up. Not out of malice toward him specifically, out of the cold logic of a scheme that needed a contractor whose name would be on the paperwork. The jury deliberated for 3 hours. They returned a verdict of not guilty on all counts. Calvin Pruitt sat at the defense table when the verdict was read and did not make any visible reaction for several seconds. Then he put his hand flat on the table, just his hand, just resting there, and took a long breath. In the gallery, 2 people who had attended most of the trial quietly left before the procedural aftermath concluded. They were identified later. Margaret Olin packed her files into her case. James Corey, who had been sitting in the public gallery, exhaled loudly enough that the woman next to him turned to look. Derek Marsh sat with his hands clasped on the table for a moment after the jury was dismissed. He was a good attorney, genuinely skilled, not corrupt, having prosecuted this case in good faith based on a documentary record that had been curated by people who understood how to make a guilty-looking record. He had been used, in his own way, as cleanly as Pruitt had been. That understanding, when it arrived visibly. He would later file a formal complaint with the state bar regarding the disclosure failures in the pre-trial documentation. Paul Stenberg resigned from Landmark Mutual 12 days after the verdict, 4 days before he was formally named in a state insurance fraud investigation. The investigation would eventually name 3 additional Landmark Mutual employees and 2 external contractors, including the coordinator who had told Pruitt to submit the documentation as provided. Harlan Voss Whitmore entered into a cooperation agreement. His insurance license was suspended pending the outcome of the broader investigation. He lost the license permanently 8 months later. View Consulting Group dissolved the same week. Crestline Technical Services, the company connected to Whitmore's firm that had done the electrical work on the warehouse 18 months before the fire, became the subject of a separate inquiry when investigators obtained its financial records and found payment patterns consistent with the fraud structure Whitmore had described. That inquiry was ongoing as of the last public filing available. The fire marshal who had classified the warehouse fire as accidental was not implicated in the scheme. His report was reviewed and the conclusion was revisited. The revised report, issued 14 months after the trial, classified the cause of the fire as undetermined, meaning the evidence was insufficient to rule out deliberate origin. That reclassification came too late to change any charges, but was included in the civil suits that followed. Calvin Pruitt did not return to Dunmore immediately after the verdict. He had a contract dispute of his own, 18 months of legal fees and professional damage to absorb. A company that had operated on skeleton capacity while its owner was navigating a federal fraud charge. And a reputation in a county where contractors live and die by word of mouth. He came back. He is still operating in Crestfield County. He does not talk about the case in detail, according to people who know him. He has described it, on the few occasions when he's addressed it directly, as a period he does not revisit willingly. There is one thing he has said publicly, in a brief statement released through Olin's office after the verdict, that seems worth closing on. He said, "I signed a contract with a name already in it. I never asked who the name was. I should have asked. Everyone should ask." Margaret Olin was asked about the case in an interview she gave 6 months after the verdict. She was asked what the turning point was, the single moment she would identify as the thing that changed everything. She didn't say the name on page 3. She said, the judge reading it. That document had been in the evidence file for months, she said. My team had seen it. The prosecution had seen it. Presumably, someone at Landmark Mutual had seen it and decided to include it in a discovery filing they expected would be treated as background. The name was never hidden. It was just unread. It was on page 3 of a 20-page exhibit in a case with hundreds of pages of documentation. Nobody read page 3 carefully. She paused. The entire case changed because a judge read a document carefully. That's it. That's what it came down to. 14 years on the bench and the habit of reading to the end of the page. What makes this case worth examining, beyond the outcome, beyond the scheme, beyond the specific mechanics of how a fraud of this type moves through a commercial insurance system, is what it demonstrates about the space between visibility and attention. The name Harlan Voss Whitmore was never concealed. It was in the filing. It had been submitted by the prosecution's supporting institution. It was, in the most technical sense, disclosed. And yet for 11 months of litigation, nobody had connected it to anything, asked who it was, or treated it as significant. The scheme, if Whitmore's account is accurate, relied on that. Not on concealment. On volume, on the reasonable assumption that in a complex document record, most things will be processed but not examined, read but not interrogated, filed but not followed. It relied, in other words, on the ordinary habits of people under time pressure with too many pages in front of them. A judge with 14 years of practice and the specific habit of reading to the end of every page disrupted that assumption in approximately 4 seconds of silence. 3 questions before you go, and I want you to actually sit with these. The first, at what point in this story did your understanding of what was happening change? Was it the name, the Whitmore Landmark connection, the Crestline electrical work, or somewhere else? Because most people who follow this case identify a different moment as their turning point, and I think that says something interesting about how we each process layered information. The second, Pruitt signed a contract with a name already printed in it and, by his own admission, didn't ask about it. Given that he was not an attorney and was working with what looked like standard commercial paperwork, do you think that's a failure on his part? Or is that an unreasonable standard to hold an individual contractor to when they're dealing with an institutional client using institutional documents? And the third, which is the one I keep coming back to. Derek Marsh prosecuted this case in good faith. He was handed a documentary record that looked complete and accurate, and he built a case on it. The scheme worked, in part because it produced documentation convincing enough to fool a competent prosecutor. What does that tell us about the assumptions we make when institutional documentation looks official and coherent? If you want to keep following cases like this one, cases where the truth lives not in a dramatic confession, but in a name on page 3 that nobody thought to read aloud, subscribe and stay through to the next video. Because in the next case we're covering, the document that changed everything wasn't a signature page, it was a date stamp. And the date was wrong by exactly 1 day. That 1 day is the entire case.